So today we are going to discuss the amendability of fundamental rights. Now for understanding this topic, we will have the discussion on the following subtopics. Some basic background information about Constitution of India. Secondly, we will discuss the amendment procedure. As given under Article 368. Thirdly, we will discuss why fundamental rights are fundamental. And fourthly, we will come to this amendment of or amendability of fundamental rights. And what is the situation as of now? Because fundamental rights, as we all understand, are called fundamental because of two reasons basically. First of all, they are called fundamental because they are derived from the fundamental law of the land, that is the Constitution. And secondly, they are also fundamental because they are one of the essential features that makes any individual go for his or her all-round development. In the absence of fundamental rights, the person may not feel comfortable in realizing his or her full potential, because the state, which is defined under Article 12, may not be always very benevolent. The state may use arbitrary power against the individual, and there are many things that can happen. So fundamental rights are important for individual to realize their full potential. Now let us start with the topic one by one. Now, Constitution of India, it was adopted on 26 November 1949 and it came into force from 26 January 1950. And why the date 26 January was selected? Because the Purn Swaraj resolution was passed, and for that very reason 26 January 1950 was selected as the date, though it got adopted by the Constituent Assembly on 26 November 1949. So these are two dates that one can remember. Then Indian Constitution, it has some significant features. It is world's lengthiest written constitution, and if we compare India with UK and US, UK doesn't have a written constitution. There is parliamentary supremacy in UK, whereas in US it is a written constitution, but it is much more rigid. The amendment procedure available in US Constitution is quite rigid, and very few amendments have taken place throughout its constitutional history, whereas in UK it has been the other way around. It is very flexible, there is no written constitution, and changes have been made very frequently. India, despite being under British rule, the constitution framers, they went for written constitution because they saw some merit in it, that amendment should not become a routine matter. So the procedure of amendment has been provided in the Constitution, but still the idea is that it is for rare cases, rare utility. And originally when this Constitution was enacted or it came into force, there were 395 articles, there were 22 parts and 8 schedules. But as of 2013, the articles have become 465. There are 25 parts and there are 12 schedules in the Constitution. This progression also shows that what effect amendment has done. Why amendment is necessary? Because the Constitution is supposed to be a living document. It should not be static, as in the Constitution was framed in 1949. So over the years, like lot of changes are bound to happen. So if the framers of the Constitution would not have provided this feature of amendment, maybe the Constitution would not have been able to live up to the changing conditions. So that's why this amendment procedure is important. And now let us see the amendment procedure in detail. So there are types of amendment. And there are actually three types of amendment procedure. One is by simple majority, the second one is by special majority, and the third one is special majority plus ratification by more than half of the states. So this is simple majority, this is special, and this is special majority plus ratification by over half of states. And there are different provisions of the Constitution which come under these three categories. So if we want to change any provision relating to citizenship articles, they are defined under Article 5 to 11. So we can directly go for a simple majority amendment. But if we want to change something related to FRs, fundamental rights, or DPSPs, then it will have to be done by simple majority, special majority. And where this ratification of states would be necessary, when we are changing anything which is related to federal provisions of the Constitution or which affects the interests of the states. So there we need to have special majority plus ratification by more than half of the states. Now this ratification which will be done by the states will be done by passing a resolution through a simple majority in the state legislatures. And provisions which are done in this way are basically related to election of the president and the manner of his election, the provisions governing center-state relations, etc. So this is special majority. Now what is the procedure for amendment? And one more thing to note here is, like these two provisions, they come under Article 368. But this simple majority changes or amendments that are made, they do not come under Article 368. So now we can see the procedure of amendment under Article 368. Now the bill can be moved in either house of the parliament, but such a bill cannot be moved in a state legislature. So only parliament has the power to actually initiate constitutional amendment under Article 368. Then there is no provision for a joint sitting of parliament to break any deadlock, and it also acts as a safeguard. Like for example, there is a majority government in Lok Sabha which is having a brute majority, and it wants to pass a bill which is maybe not in the best interest of people, and then at least Rajya Sabha can act as a check or a safety valve. And once the bill is passed by special majority, now what is a special majority? A special majority is comprised of two cases where you need to have a majority of total membership of the house, and secondly you need to have a majority of 2/3 of present and voting. So these two conditions need to be satisfied for it to be a case of special majority. So both houses will have to pass the Constitutional Amendment Act separately, and once it is passed, if it is not concerning any federal provision, then the ratification by states is not required. Then it will be given to the president. One more thing is there, like who introduces such a bill. So this bill can be introduced either by a minister, that is by the government, or by any private member. And once this bill is passed by following the procedures of passing by special majority by each houses of the parliament, then it goes to the president for assent, and the president is bound to give his assent. President cannot deny it or withhold it. So once it is passed by the houses of the parliament, it is more or less certain that it will become an act, and once the presidential assent is received, the constitution stands as amended by that act. So this is the procedure. There is some criticism that of the amendment procedure, that it doesn't provide for joint sitting to break any deadlock, and all that only parliament can move a amendment act, and state legislatures have not been given that power. But overall, if we see, still the constitutional amendment procedure that the framers of the constitution have adopted has been largely successful, and it strikes a very fine balance between flexibility and rigidity which is required. So now let us come to the fundamental rights. Yes. Yes.
Sir, can the executive amend the constitution by means of an ordinance?
Constitution by means of an ordinance.
Can constitutional amendment be carried out by means of an ordinance, like any other ordinary legislation is done?
I don't think so. Like it can be done by passing an ordinance, because Constitutional Amendment Act, as the name suggests, it needs to be passed by both the houses with special majorities. So I don't think it can be passed by an ordinance. Yes.
What are your views about the judicial pronouncements which result into some kind of changes in the nature and even the meaning of the provisions of the Constitution?
I think judiciary has been, even by the framers of the Constitution, it has been given a responsibility to act as the custodian of the Constitution. So, and judiciary has the power and the responsibility to interpret the Constitution. So, whatever judicial pronouncements have come, at times there have been allegations of judicial activism, judicial overreach, and such terms have been used. But if we see over the years, over the last 60-70 years of the constitutional experience, it will be fair to say that judiciary has generally done the right thing, and they have tried to maintain the sanctity of the ideals of the framers of the Constitution. They have actually tried to uphold them, even at the risk of antagonizing the government of the day. And I think people all over India generally have like huge respect for the judiciary, and that is one institution which has remained very much aloof to the overall corruption that one can say in the society. So I think I'll support that view, that the judiciary has largely been on the right side, and it has struck a fine balance. Okay. So now let us see the fundamental rights. Fundamental rights, as you may be aware, are mentioned in part 3 of the Constitution, and they cover articles from 12 to 35. And as I earlier told, that fundamental rights are called fundamental because they derive themselves from the fundamental law of the land, which is the Constitution, and they are very essential or basic for an individual to realize one's full potential. So that's why they are called fundamental. And on top of it, fundamental rights form the bedrock of the democratic system that we have. They protect individual liberty, they ensure that there is rule of law, they ensure that